It is a Tuesday night on Highway 401 outside Toronto. Cold rain, wipers going. You are doing the speed limit. You have had a long shift, and you just want to get home. If this is your first time here, subscribe. Then the blue and red lights fill your rearview mirror. Your stomach drops. You pull onto the shoulder. The officer walks up, taps your window, and before you have even got your license out of your wallet, they lean in and ask that friendly, almost casual question. Evening. Know why I pulled you over tonight? And here is what 9 out of 10 Canadians do. They panic answer. Was I speeding? Maybe I rolled that stop sign back there? Sorry, officer. I think my taillight might be out. And just like that, in a single polite, apologetic breath, you have handed the officer a confession. You admitted to an offense you were not even necessarily being stopped for, and every single word of it is now written into that officer's notebook, and it can be used against you in a court of law. You did not get in trouble because you broke the law. You got in trouble because you were polite and nervous at exactly the wrong moment. And that is the thing I need you to really sit with right now. The most dangerous moment on that roadside is not the flashing lights. It is not the handcuffs. The most dangerous moment is not the obvious one. It is the one that looks completely normal. It is the friendly question through a half-open window. It is the small talk. It is the part where nothing feels like a legal event at all, and that is exactly why it is the part that sinks people every single time. So here is what I am going to do. I am going to walk you through 2 very real situations. Situation 1 is your ordinary traffic stop, the know why I pulled you over trap that catches Canadians every day. Situation 2 is when that same stop turns into something far more serious, and the legal rules flip completely on you in ways most people never see coming. For each one, I am going to give you the exact words to say, word for word, so you are not inventing anything under pressure. And I am going to show you the real sections of the Canadian Charter of Rights and Freedoms that back you up, plus the real Supreme Court of Canada cases that decided all of this decades ago. This is not American TV law. There are no Miranda rights here. None of that. This is Canadian law, and it works very differently than most people think. Let us get into it. Picture it. You are driving home. Regular night. Nothing unusual. You get pulled over. Could be a speed check. Could be a random stop. Could be a burnt-out taillight you did not even know about. The officer comes to your window and hits you with the classic line. Do you know why I stopped you tonight? Now here is a common misconception. Most Canadians believe that being friendly and cooperative means answering every single question the officer asks them. They think that if they just explain themselves, if they are honest and apologetic, the officer will go easy on them. People genuinely believe that talking their way through it is the safe, respectful, law-abiding thing to do. It is not. And it is important you understand exactly why the law treats your words the way it does. In Canada, you have the right to silence. It flows directly from Section 7 of the Canadian Charter of Rights and Freedoms. Section 7 reads, "Everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice." The Supreme Court of Canada has repeatedly held that one of those principles of fundamental justice is the right to silence and the right against self-incrimination. You are not required to help build the case against yourself. Full stop. That is not an opinion. That is settled Canadian law. Here is the analogy I want you to hold on to. Think of a traffic stop like a job interview where you do not actually want the job. Every extra thing you volunteer can only hurt you. It cannot help you. You answer the required questions, you are polite, and then you stop talking. You do not ramble to fill the silence. Because in an interview, and on that roadside, the person across from you is evaluating everything you say, and only the wrong answers get written down. The right answers do not protect you. The wrong answers destroy you. Now, and this is the part that most people get completely wrong about Canada, the right to silence has specific limits at a traffic stop, and you need to know exactly where that line sits. When you are driving, you are operating a licensed activity on a public road. Under every provincial and territorial Highway Traffic Act in Canada, the Highway Traffic Act in Ontario, the Motor Vehicle Act in British Columbia and New Brunswick, the Traffic Safety Act in Alberta, and their equivalents everywhere else, you are legally required, on demand, to produce 3 things: your driver's license, your vehicle registration, and your proof of insurance. You also have to give the officer your name and address. That part is not optional. Refusing to hand those over is itself an offense that will get you charged or arrested on the spot. And this core rule, license, registration, insurance, and your name, is consistent right across every province and territory in Canada. The Supreme Court of Canada has confirmed that police can stop you at random just to check those exact things. In R.V. Ladouceur in 1990 and R.V. Hufsky in 1988, the court held that random vehicle stops to check your license, your insurance, and your sobriety are constitutionally permitted in Canada. So when someone says, "You cannot just pull me over for no reason," that argument does not work in Canadian courts. They can. The Supreme Court said so. So here is the distinction that actually protects you, and I want you to burn this into your memory right now. You must identify yourself and produce your documents. You do not have to explain, confess, or narrate a single thing beyond that. And here is what it sounds like when the officer is working the trap. They lean in, all friendly, completely relaxed. "How is your night going? Know why I pulled you over? You seem to be in a bit of a hurry back there. Where are you coming from tonight?" Sounds like small talk. It is not small talk. Every single one of those questions is designed to get you talking. "Where are you coming from?" is checking whether you are leaving a bar. "You seemed in a hurry" is inviting you to admit you were speeding. "Know why I pulled you over" is asking you to confess for them so they do not have to prove it themselves. The friendly tone is the whole point. It is a technique, and it works because it does not feel like a technique. I see people make this mistake all the time. They think silence looks guilty, so they over-explain to seem innocent. And the trap is that the friendlier the officer sounds, the more people talk. You feel like you are having a conversation between two reasonable adults on a rainy roadside. You are not. You are being interviewed, and it is being recorded, on the cruiser camera, on the body camera, and in that officer's notebook. Think about what happens when people start talking. "I only had a couple of beers." That is evidence of consumption. "I was maybe going a little fast." That is a speeding confession from your own mouth. "I am coming from my buddy's place. We were watching the game." That is evidence of your location, your timeline, and your company, all of which can be used to build a case against you. Every one of those sentences handed the officer something they did not already have, and you gave it all away for free, out of politeness and nerves. So here is exactly what you say. You hand over your license, registration, and insurance. You look at the officer calmly and you say these words. "Officer, I am happy to give you my license, registration, and insurance. I would prefer not to answer any questions." Let me break down why every single piece of that sentence is doing important legal work. I am happy to give you my license, registration, and insurance. This shows the officer you are complying with your actual legal obligation under your province's highway traffic legislation. You are not obstructing. You are not being difficult. You are doing exactly what the law requires. That means the officer has zero grounds to escalate the situation or arrest you for refusing to cooperate, because you are cooperating with everything that is legally required of you. I would prefer not to answer any questions. This is you exercising your Section 7 right to silence, calmly and clearly, and without any confrontation. Notice the word prefer. It is polite. It is not aggressive. It is not, "I know my rights and you cannot do this to me." It is a soft, firm, legally meaningful boundary. And critically, it says absolutely nothing about the alleged offense. You have not admitted to speeding. You have not said where you came from. You have handed over the paperwork the law demands and nothing more. Now here is the honest caveat, because I am not going to sell you a magic spell that makes tickets disappear. Saying this phrase will not make a ticket vanish. If the officer clocked you on a calibrated radar unit doing 130 in a 100 zone, staying quiet does not erase the radar reading. This phrase does not stop you from receiving a ticket. It does not stop the officer from continuing their investigation into whatever they stopped you for. What it does is protect you in court, and that protection is enormous. When you fight that ticket, or if things ever get more serious than a ticket, the Crown must prove its case. If the only evidence is a radar reading, that reading can sometimes be challenged. Calibration records, positioning of the device, the officer's sight line. But the moment you said, "Yeah, I was probably going a bit fast," you handed them a confession from your own mouth. And confessions from your own mouth are almost impossible to fight in court. You cannot cross-examine yourself. So what this phrase protects is your future ability to actually contest the case, instead of having already lost it before you left the shoulder of the road. Silence keeps every option open. Talking closes them one by one. And once they are closed, no lawyer in Canada can open them back up for you. Now let us change one single fact, and watch how much it changes everything around you. Same night, same highway, same stop. But this time, after you hand over your documents, the officer's tone shifts. They step back slightly, look at you a little longer than feels normal, and then they say it. "Have you had anything to drink tonight?" Or, "I am going to need you to step out of the vehicle and blow into this device." The rules just flipped completely. And if you handle this situation exactly like situation 1, if you think the lesson was just stay silent and refuse everything, you are about to walk straight into a criminal charge that will follow you for years. Because here is where a lot of people flip directly into the opposite mistake, and it is just as damaging as the first one. In situation 1, the lesson was that you do not have to answer questions. Some people overlearn that lesson and assume it applies to absolutely everything the officer asks of them. They think, "I will refuse the breathalyzer. That is my right to silence. They cannot make me blow." That thinking is dead wrong. It will get you charged with a criminal offense that carries the exact same penalties as impaired driving itself. Let me tell you exactly why. Section 320.27 of the Criminal Code of Canada, brought into law through Bill C-46 in 2018, created what is known as mandatory alcohol screening. Under subsection 2 of that section, once you have been lawfully stopped, a police officer who has an approved screening device available can demand a breath sample from any driver, and they do not need any reason to suspect you have been drinking. Zero suspicion required. Not a smell of alcohol, not red eyes, not slurred speech, nothing. If you are behind the wheel and you have been lawfully pulled over, they can require you to blow into that device right there on the roadside. And refusing is its own separate criminal offense. Refusing or failing to comply with a breath demand under the criminal code carries a mandatory minimum fine of $2,000 on a first offense, plus a driving prohibition, plus a criminal record that does not go away. You are punished as if you failed the test and were impaired. So the decision to just refuse the breathalyzer is not a clever legal move. It is one of the most expensive mistakes you can make on a Canadian road, and it happens all the time because people do not know this law exists. Here is the analogy that makes this clear. A breath demand at a traffic stop is like the security screening at an airport. You might have all sorts of privacy rights in your daily life outside that building, but the moment you walk into the airport and choose to fly, you agreed to the screening process, and you cannot stand at the checkpoint and tell the officer you decline. Driving is the exact same bargain. The privilege of using public roads in Canada comes bundled with the obligation to submit to a lawful breath demand when one is made. You do not get to opt out and keep your license. Now that said, you absolutely still have rights in this situation, and they are powerful rights. The breath sample is mandatory, but your words are not. Your mouth still belongs to you. And here is what it sounds like when this situation turns serious. The officer makes the demand, reads you the required warning, and you step out of the vehicle. Then, while you are standing on the shoulder in the rain, the questions start again, but now they are sharper than the friendly small talk from before. How much did you have tonight? When was your last drink? You were at the bar earlier, weren't you? Come on, just be honest with me and this will go a lot easier for you. I see people make this mistake all the time. They comply with the breath test, which is the right move, but then they keep talking while they do it. They think that cooperating and being open about everything will earn them mercy or a break from the officer. So they fill the silence with words. I only had 2 drinks. That is evidence of consumption, now on record. My last one was about an hour ago. That is evidence of timing, now on record. I feel completely fine, honestly. That is evidence the Crown will use to show you misjudged your own impairment, also on record. Every single one of those sentences is now part of the case against you. You have done the prosecutor's job for them, standing on the side of Highway 401 in the rain. And there is one more right that kicks in the moment you are detained or arrested in this situation, and it is one of the most important rights in the entire Charter. Under Section 10(b), everyone has the right on arrest or detention to retain and instruct counsel without delay and to be informed of that right. The moment you are detained, not just stopped but actually detained for the purpose of a sobriety investigation, you have the right to speak to a lawyer before further questioning, and the police have a legal obligation to tell you about that right and to give you a meaningful opportunity to actually use it. And alongside that, Section 9 of the Charter protects you from being arbitrarily detained in the first place. The Supreme Court laid out the modern framework for exactly when detention occurs and what happens to evidence when police cross the line in R.V. Grant in 2009, one of the most important charter decisions of the last 20 years. That case established a 3-part test that Canadian courts use to decide whether evidence gathered in violation of your charter rights should be thrown out entirely. So here is exactly what you say when the stop turns serious. You comply with the breath demand. You blow, because refusing is a crime, and the fine starts at $2,000. And then for everything else you say, I will do the breath test because I understand it is required. Beyond that, I am going to remain silent, and I want to speak to a lawyer. Let me break down what that sentence accomplishes because it is doing 3 critical jobs at exactly the same time. I will do the breath test because I understand it is required. This keeps you completely clear of the refusal charge under Section 320.27 of the Criminal Code. You are complying with the one thing that is genuinely mandatory in this situation. You are not obstructing. You are not resisting. You have protected yourself from the automatic $2,000 minimum fine, the driving prohibition, and the criminal record that comes with a refusal conviction. Beyond that, I am going to remain silent. This is your Section 7 right to silence, and this is where you stop feeding them evidence that will be used against you. The approved screening device measures your breath sample. It does not need your commentary about how many drinks you had, when you had them, where you had them, or how you feel. None of that information has to come out of your mouth, and if it does come out of your mouth, there is no taking it back. And I want to speak to a lawyer. These 7 words trigger your Section 10(b) right to counsel. And the moment you say them clearly, the police have a legal duty to give you a meaningful opportunity to actually contact a lawyer before they continue questioning you. They must hold off on further interrogation until you have had that chance. Your lawyer can be reached through legal aid in every province. It is free and available 24 hours a day. Saying these words out loud puts the officer on notice and puts the charter protection into motion. And then, this is genuinely the hardest part of everything I have told you tonight. You actually stay quiet. I mean that completely. This is the part people simply cannot do. You have said your phrase, you have asked for your lawyer, and now the cruiser is parked on the shoulder behind you, and the officer is not saying anything, and the silence stretches out, and your brain is screaming at you to explain yourself, to smooth it over, to say something, anything, to make that terrible tension go away. That urge, that physical discomfort, that desperate need to fill the quiet, that is the single thing that talks more Canadians into a conviction than any police technique ever invented. So let this sink all the way in before you ever find yourself on that shoulder. Awkward silence has never once been used as evidence against anyone. Not once. Not in the entire history of Canadian criminal law. No one has ever sat in a courtroom and been convicted because the car got quiet after they asked for a lawyer. People are convicted every single day in this country because they filled that quiet with words, because they could not sit with the discomfort for 90 seconds. Let it be awkward. Awkward silence is free. Talking is expensive, and the bill comes due in a courtroom months later when you are sitting across from a Crown attorney who is reading your own words back to you. All right, let us pull all of this together into 3 simple points you can actually hold on to and remember when it counts. Because the whole reason we went through all of this is so you are not standing frozen and afraid on the shoulder of a wet highway, trying to remember what you were supposed to say. Number 1. In an ordinary traffic stop, you must hand over your driver's license, your vehicle registration, and your proof of insurance. That part is legally required in every province and territory in Canada without exception. But you do not have to explain anything. You do not have to confess anything. You do not have to narrate your evening. Your phrase is, "Officer, I am happy to give you my license, registration, and insurance. I would prefer not to answer any questions. Documents, yes. Confessions, no." That is the line. Number 2. The moment the stop becomes a sobriety stop, the rules flip, and they flip hard. A breath sample under Section 320.27 of the Criminal Code is mandatory, and refusing it is a criminal offense carrying a $2,000 minimum fine and a criminal record. You blow. But your mouth is still yours after that device comes down. Your phrase is, "I will do the breath test because I understand it is required. Beyond that, I am going to remain silent, and I want to speak to a lawyer." Comply with the test. Say absolutely nothing else. Let your lawyer do the rest. Number 3. Here are the 4 charter sections that protect you across both of these situations, and you should know what each one does so you understand exactly what is in your corner. Section 7 gives you the right to silence and the right not to incriminate yourself. That is the section that lets you stop talking and keeps your words out of the evidence against you. Section 8 protects you against unreasonable search and seizure. That is, the backbone of cases like R.V. Mellenthin, where the Supreme Court of Canada threw out evidence gathered during a search that went beyond what was legally permitted at a check stop. Section 9 protects you from arbitrary detention. That is, the foundation of R.V. Grant in 2009, the case that established how Canadian courts decide when detention has crossed the line and what happens to the evidence when it does. And Section 10(b) gives you the right to speak to a lawyer the moment you are detained or arrested, and the right to actually be told about that right in terms you understand. That is the section that triggers the police obligation to give you a real opportunity to get legal advice before they keep questioning you. 4 sections: silence, search, detention, and a lawyer. That is what stands between you and the mistakes that end careers, cost fortunes, and follow people for decades. Save this video so you have both exact phrases the moment you ever need them, because you will not want to be inventing the words under pressure, in the rain, with lights flashing in your mirror. See you in the next one.